the smartest guy with a bow tie in Chattanooga, Tennessee, David Tulis.
Okay, you're waiting with bated breath for the Tulisian explanation of an injustice that is almost impossible to see. It's almost impossible to see unless you have, I would suggest, a Christian or biblical or, let's say, church-informed base of presuppositions. And that is, how is it that the state can prosecute crime and alleged criminals in its own name, and what is the effect of it doing so? I've been thinking about this all week, and I've been writing about it and discussing it and kind of highlighting Neil Pinkston's role as chief of the Fellowship of the Finger, that is to say, the accusatory finger of the modern state. The modern state is always, because it is the executive state, it is the surveillance, warfare, and welfare and police state, it is the state of accusation. And it does offer benefits, it does offer consolations, it does offer welfare debit cards and the like, and protection. I got to remember that. And safety. Got to remember that. But on the other hand, it is the chief accuser, and the Fellowship of the Finger is, in our county, Neil Pinkston elected office. We get to pick our accuser. And then it's also the police departments and sheriff's departments in the area. And these are, of course, the chief manifestations of the modern state is the police. That they have grown exponentially across the landscape, and there are 500 of them almost in Chattanooga. And in many ways, we can say that they are eating out our substance and bringing us to our knees. That is what we're supposed to be. That is our proper position, is on our knees in submission. And we can see all across the country videos of abuse by people who don't have the proper submission and who don't recognize the true state of affairs between the people and the state. Now, let me just cut away from that point to suggest that the mystery. There's a mystery here. How is it that the state can prosecute in its own name? And what is the effect of it? Well, it comes under the doctrine of parens patriae, which is, if you look at, just Google that, and the government or any other authority regarded as the legal protector of citizens unable to protect themselves. And who would that be? Well, is it just children with defective minds, or defective brains, or is it the homeless? Is it school children? Is it divorcees with children who need to be supported by their ex-husbands? Well, in fact, it's everybody. And because of this doctrine of parens patriae, which is connected to another one called in loco parentis, which is to say in the place of parents, right? In the location of parents. In loco is location, parentis is parents. In loco parentis, that doctrine, which often is applied to school children in custody of the state, when the yellow bus, on the yellow school bus and through the gates of hell comes to pick you up, that doctrine is invoked there to describe that relationship. You give up your parental rights, as it were, and the state takes over for the 8 lovely hours that your child is in the factory, learning to be a good citizen, and so on. Now, because we have this doctrine, we have what happens is a subtle replacement of God as the governor of the universe with the state. The state is in fact the owner of all. And the state has a presumptive claim upon all people. That's how police operate, and that's how you can see in these police abuse videos that are just rampant. It is a rampant problem, you might say, for policing. This exposure, not seen before in the past 3 or 4 years, is just suddenly broken out, and that whole industry, the whole police judicial industry, is reeling to figure out how to make the best of it. The police union is beside itself, and trying to figure out how do we recover from this bad publicity. Well, there's a problem. The problem of parens patriae is when the state assumes authority and control and for protection, right, legal protection over all, God is knocked off the throne. And it is a theological problem in the end. It is a theological problem that I hope your minister at your church is aware of, because it is a leading, it is the fruit, the fact that problem is not recognized in Christianity is a fruit of the kind of Christianity we have today, which is the privatized Baptistic Armenian form, which rejects the sovereignty of God, of course, it rejects sovereign grace, it rejects the sovereignty of God, and in effect, denies the crown rights of King Jesus, which other Christians hold, a few Christians hold to be the true doctrine that gives us comfort and direction in our work as citizens and as people, some of us in public office. Now, the problem is the legal problem I'm trying to describe is when the state takes the place of God is standing. It is called standing, and we see the problem whenever there's a prosecution brought to your attention by the Fellowship of the Finger Partner A, that is the cop, and Fellowship of the Finger Partner B, that is Neil Pinkston. The case is always styled State of Tennessee versus you, John Doe. Okay, you, my listener, John Doe, the man who matters. But in this case, you're just a subject. How is it that the state is the offended party? And the reason I ask that is because the doctrine of standing is in my mind, and there are essentials for standing that require that the person filing the case, right? It is a threshold question: who has authority to file this case? Who has reason to file this case? There are three parts of that, and one of them is that the plaintiff, the person filing the case, here we have a criminal case, has to show a distinct and palpable connection between the injury and the claim, right? There has to be an actual damage, a legally protectable and tangible interest at stake. Well, that's the second point. There has to be a real injury, an injury that is distinct and palpable and not conjectural. And then the second leg of standing is that you have to establish a causal connection between the injury and the conduct of which the suit or the indictment complains. And then third, it must be likely that a favorable decision will redress the injury. These are indispensable elements of standing, and Neil Pinkston often doesn't have any of them. Who is the state? What is the state? How does the state show itself to be the victim in a murder? Okay. Now I'm trying to get back here to the police execution of the plumber Todd Browning in East Ridge. The suit is by Heather Schmidt and Brandy Browning, his daughters. He was executed by an officer, but the execution was cleared. It was said to be fine. It was legal. It was a statutorily allowed extrajudicial summary form of capital punishment. That's what it is, against a man who had not been convicted of a capital offense. And that happens through the statute. The police have a protective, you might say, a carapace, a shell around them that protects them from liability that you don't have. I don't have, probably because we're not wearing blue. Right? There is a power of blue in the statute. When the state did not prosecute the officer Daniel Stevenson, it did not prosecute him. Had it done so, it would have filed the case as State of Tennessee versus Daniel Stevenson. But here, why didn't it do that? Well, the state, the state is always reluctant to prosecute one of its own, right? One of its own. These prosecutions are rare. Let's say in short, they never happen. Okay, they rarely happen. It's so rare that you could say, almost speaking generally, they don't happen. And so the case is always styled State of Tennessee versus Daniel Stevenson. Didn't happen. And so now we have a civil case where the two daughters are suing him and the city of East Ridge for this execution on video. By the way, you can see that video at Nooganomics.com. Subscribe to Nooganomics.com. You should really subscribe to that website if you are the man who matters. You, my listener, are the man who matters. You can be doubly so. Tuning in here for 5 minutes. That's all I need from you. 5 minutes. The David Tulis Show. And then you can subscribe there and get my text. These texts are important, but they go in deep. Okay, they go in deep, and it's not too much type. It really isn't. Though I tend to write between 1,500 and 3,000 words per post. Some might say that's long, but it really isn't. Every criminal case, to reflect a godly order, if I can just get back into the gear here, every criminal case should be styled properly. The victim. So let's say it should be Mark Heinzer, who's a man who works in city government. Let's say Mark Heinzer is killed by someone in a criminal act. Mark Heinzer, survivors, X-Rail, State of Tennessee versus John Doe. Okay, John Doe is the accused, and it is Mark Heinzer who's the victim and his family. And the case is brought not by that family, but by the state, because it is a public matter, not just a private wrong. And so the state has an interest. I think there may be a fault biblically between that distinction between criminal and civil, but let's just accept for the moment that it is acceptable. We won't question it for now. The state brings the lawsuit against a criminal party but only on the relation of. Ex rel means on the relation of the state of Tennessee. So the family doesn't have to bear the expense, doesn't have to hire anybody, does not have to lose a third of the proceeds if there is a reward to the attorneys. Attorneys sue on contingency; they demand a third of the payout of the reward. So private litigation always has that expense that is factored in. The attorney gets a third. So there is never really full compensation in a civil case if you have an attorney whom you've hired in the compensatory, in the speculative method that's very common today. Well, there should be, the case should be, when the state files it, it should be always in the name of the person. Why? Why is that important? Well, because the state should have what God says is important in every wrong, and that is the rights of the victim in view first. The victim's rights matter first, and our jurisprudence in Tennessee, all across the country, rejects this biblical requirement. And so you could say that our court system is anti-God, okay? If you know people who are Christian, run that by them and ask them if they are upset. Our court system is anti-God because it replaces restitution with prison. And though you have a constitutionally guaranteed right to restitution, that never happens. That has never happened. And when criminal matters, there's never, ever, ever restitution. It's just not done. And even though it's written in the Constitution, in the victim's rights portion of it, is at the very end of that document. And so my concern is that what do I want? I want that you, my listener, yearn for a reform, yearn for justice, where the victim is first, where restitution and compensation and restoration are first, not the integrity, honor, and parens patria of the state of Tennessee, not the state being God, the state replacing God, the state being the offended party. The reason, why does the state do that? Well, because biblically, God is the chief offended party of every crime. In God's law, God is offended by adultery. He's offended first by murder, rape, by sexual abuse, by fraud. He is the offended party in every public sin, right? A crime is a public sin. Many sins are simply private, right? There's no public, immediate public evidence of it, so it's a private sin against God. But all sin tries to victimize God. And here the state, understanding that, the modern state, the religious corporation, the legal fiction, which is the state, recognizes that, and so replaces God as the offended party. That's why the cases are no longer styled People of Tennessee versus, or they're not styled Mark Heinzer, victim, comma, survivors thereof, comma, ex-rel state of Tennessee versus the accused, John Doe. They're not styled that way because the state has claimed to be the offended party. The state has replaced God. This is a theological problem. This is a problem that theologians look at, some of them. Gary North would be one. R.J. Rushdoony would be another. Gary DeMar would be another. Joel McDermott would be another. At least one of those is deceased, but the others are living writers today. They look at that as a problem and see it, and they try to explain it to Christian people. They want Christian people to have an interest in this matter. It is Cash Friday, and I'm sure these writers would have you, my listener, and then Christian people, other Christian people, or just Christian people, to take an interest in this matter. And again, it's the question of standing. How can Neil Pinkston prosecute anybody if he doesn't have standing legally? How is it that the state can pretend that the rules for standing apply in civil matters, but not in criminal matters? And this is a question, by the way, that has been raised by a very, very important defendant, a man whom I would say is a representative of tens of thousands of people in Tennessee. And that is Arthur J. Hirsch, who is fighting to overturn the unconstitutionally vague gun law in Tennessee. That's the carrying with the intent to go armed statute, which is written against black people. It is strictly anti-Negro, because I say Negro because it was written at the times when black people were called Negro. You could say it's an anti-African-American statute. They weren't called that back then, but they were called Negroes or other words. It was written against them to suppress their ability to defend themselves. And we need to understand that this whole doctrine of parens patria is wrong. It displaces God, and it violates legal principles. We have to understand that the state does that all the time. It is a common practice in government. It is a common practice in regulation. It is a routine in the prosecution of alleged crimes to twist the meaning of a statute to make it conform to the circumstances that the prosecutor or the cops, the regulators, or the enforcers want to bring about. That's what they do. It is wrong. It is a form of judgment. Okay, let's just put it that way. It is a form of judgment against people who don't see the problem. Right. I think if we have here in Chattanooga a desire for better things, a desire for reformation, you might say a desire for blessing, that we need to understand these are real problems. These are real problems, and I'm here every day to suggest that we should want blessings. We should understand that when we're under a judgment, we should understand it should be painful. We should feel the pain of this judgment. We should feel the pain of our shackles in the shadow of the pyramid under which we live today. That is the pyramid of Egypt, or you could say the pyramid under the pyramid of Washington. It's on the back of the $1 bill. I'm not making this up. and we have, because we're under this shadow of the pyramid in Washington, and even the one in Nashville, though there is a real one in Memphis, kind of reminding us of our spiritual heritage as heathens. We are under a pyramid, and we have much less blessing than we have much less blessing than we want, but I think we don't want it sufficiently. And that's why we have it. And we don't even feel the pain. We don't even feel the pain. We are numb to it. We are numb, comfortably numb. And it's Cash Friday today. And this is David Tulis. And so I need to move on here. I'm running out of time. I don't want you to escape yet. Okay. Don't escape from me yet. Now, I've got correspondence. I have inside information on many fronts. I just want you to know that. One of my correspondents in the prison system, I have two very fine men in the prison system. One, I'm holding an administrative notice of this man in Wartburg. I got a copy. Governor Bill Haslam, got a copy of it as well as others. Sharon Rondeau, David Tulis. I'm the second one on the list of getting a copy. It makes notice of problems in the prison system in our state. And what I like about Grenda Harmer is he thinks just like I do about many things. He looks at the law and sees the deviation. Where is the deviation from the statute or the constitutional requirement or the policy provision written by the good people in the General Assembly to control and regulate the function of the state slave system? It is, by the way, a slave system that we have in Tennessee. And we give a euphemistic name to the organizer and holder of that body of public capital, that being the Department of Correction, overseen by TDOC Commissioner Tony Parker. The date of this document, November 28, from Grenda Harmer. And it's regarding Morgan County Correctional Complex Warden Sean Phillips. And he cites in the REs at the top the statutes and provisions that are being violated. Now, let me just give you a sample, okay, just a quick sample of this man who writes very neatly. I appreciate handwritten documents that are neat because I'm the slow man of Chattanooga. They call me, laughingly, they call me the smartest guy with a bow tie in Chattanooga. But that's not true. I'm the slow man. And I'm the slow man because I ask the dumb question, the dumb slow man questions. And I just don't get so many things. I'm just so slow, like a slow man looking at a spinning whirly gig in front of him. He's not quite sure which circle is moving within which, and which one where the handle is that he should grab. That's me, David Tulis. And I do thank you for giving me just a minute of your time. You can tell I drank a lot of coffee this morning, can't you? I'm talking more quickly than normal, getting one extra story in for your edification. You give me 5 minutes and you get 1.5 stories from me ordinarily, but today you're getting two. 2 stories from David Tulis, and the number is 800-8949, 800-8949. So let's say fact number 2. The policy number, he has a long number with parentheses, Roman numerals, letters, and numbers. Requires the counselor and unit officer shall conduct reviews of the inmate's placement and adjustment at least every 7 days for the first 60 days. My first 60 days, Counselor Bill Cowherd and Corporal Jay Wallace never reviewed my placement on PC unit. Counselor Cowherd merely walks through quietly and quickly while Corporal Wallace sits or sleeps most of his shift. If Counselor Cowherd or Corporal Wallace signs documents stating they discussed my PC placement with me the first 60 days, they falsify the state documents. A crime, he says, all capital letters, a crime. Special note, section Roman numeral 6F2 requires after first 60 days to contact the inmate at least monthly. Now, that's fact number one of fact number two. Fact number three, I'm skipping here. Another TDOC policy, requires at least once every 30 days, a hearing shall be conducted by the Protective Services panel. I've been on PC status for over 103 days, and no PC panel board has seen me or other offenders since being initially assigned by PC board at Unit 26. You're getting lost? If any PC board member signed a document stating that they have seen me since initial placement at Unit 26 has falsified a state documented crime. This is my correspondent. I have inside sources, and you know what? You are getting the benefit of my inside information. David Tulis, Nooga Radio.
Traffic, news, and information. Nooga Radio. Digital FM 95.3 HD.